So good evening, everyone. Welcome to the monthly knowledge webinar conducted by Kelp along with the Indian Lawyers Association. For all those who are here on this platform for the first time, I would like to brief you about what this monthly knowledge webinar is about. So we at Kelp, along with the Indian Lawyers Association, conduct this monthly knowledge webinar wherein we choose a topic from the POSH Act or related subject matter and discuss over the same. We also call upon industry specialists as panelists to share their experience and observations on the topic. Our topic for the day is virtual harassment, ensuring safety in remote and hybrid work environments. As we continue to navigate the evolving landscape of hybrid and remote work, one thing that requires our urgent attention is virtual harassment. While technology has enabled us to work across geographies and different time zones, it has also opened new avenues for misconduct that often go unseen, unheard, and unnoticed. Today, we'll explore how organizations and individuals can create awareness, prevent, prohibit, and also respond to this raising concern. We'll also speak about strengthening workplace policies, raising awareness, and ensuring that digital professionalism and psychological safety go hand in hand. We have two extremely talented individuals here as panelists today who will share their ideas and aspects on the topic. Speaking of the panelists, I would like to introduce you to our first panelist for the day, Diksha Malik. Diksha is a principal associate with employment, labor, and benefits practice at Khaitan & Co. Diksha advises on the entire spectrum of employment matters from hiring and workforce engagement to disciplinary issues, employee exits, and workplace inclusivity. She has deep expertise in the areas of sexual harassment prevention and diversity and inclusion, and regularly works with clients to build safety and equitable workplaces. She is also the author of an acclaimed book, Sex-Based Harassment in the World of Work, which explores evolving jurisprudence under India's POSH law. A recipient of several accolades, including BW Legal World's 30 Under 30 and Modak's first Thought Leadership Award in Employment and HR for India, Diksha brings both insight and impact to this conversation. Welcome, Diksha. We're glad to have you here.
Thank you so much, Sakshi, for that lovely introduction.
Our second panelist for the day is Vasundhara Vetula. A graduate from Government Law College, Mumbai, Vasundhara has nearly a decade of experience in rights-based litigation and access to justice. She worked alongside renowned women's rights lawyers, Advocate Veena Gowda, supporting survivors of domestic violence and contributing to POSH trainings and inquiries. Her global expertise include work with NILAG in New York and International Transports Workers Federation, which researched the impact of workplace violence on women in public transport. Since 2020, Vasundhara has actively served as an external member on internal committees, conducted numerous POSH trainings across sectors from corporate offices to construction sites, and helped organizations strengthen their POSH compliance and workplace safety practices. Welcome, Vasundhara. We are extremely glad to have you here.
Thank you. Thank you, Sakshi.
So without wasting much time, let's just quickly delve into the questions that we have today for our panelists. My first question shall be to you, Vasundhara. Does the POSH Act address virtual harassment in Sexual Harassment Act?
Start off with how it defines workplace. I think all of us know it's defined very broadly. So there is the idea that it could be, transportation taken by an employee, especially aggrieved women. It could be any place arising out of employment. So that's how it's defined. So it's been defined broadly, but it does not specifically say virtual workplace. So we then look to not just the act, we also look at then interpretations by different courts on cases that have come up over the years. And since the POSH Act is relatively new, if we had to look back to older cases, when in the 1950s workers' compensation cases were being adjudicated, even then the term arising out of or during the course of employment, it's been understood to cover spaces that are beyond the four walls of a factory or an office. So historically, there is that interpretation, even if it's not, specifically laid down under the POSH Act, virtual. So that is one way to say, does that extend to virtual? And the second thing is, of course, I think more recently, when we look at sexual harassment cases, there's the landmark judgment of Saurabh Kumar Malik versus the Comptroller and Auditor General of India. So even in that, the argument made by the respondent was that this doesn't fall in the jurisdiction of the IC because it's not the mess where the aggrieved woman was residing, that's not workplace. So even there, the court has said, no, it will be considered workplace. And finally, all of us know about the Sanjeev Mishra versus Bank of Baroda case. The Rajasthan High Court then clearly said that digital platforms will be included under extended workplace. So that's where, we have this understanding of extended workplace coming from. So all in all, I think, firstly, if I had to say the act, does it talk about virtual workplace? I would say in some sense, yes, it does. And secondly, it talks about sexual harassment itself, right? It's talking about sexually colored remarks, demands or requests for sexual favors, showing pornography. Is all this said to be restricted to in-person interactions? No. So I believe that also could mean that, yes, virtual platforms are included. There could be unwelcome flirting, which happens. So that's sort of the understanding I have, Sakshi. But if Diksha wants to add anything, I'd love to hear her thoughts.
We'd love to hear Diksha's thoughts on that.
No, I think I completely echo what Vasundhara is discussing, and the case law that she referred to is bang on point. Ultimately, if you look at even the past jurisprudence, not specific to posh law, but generally on the concept of misconduct, you will see that courts have always emphasized on nexus to work or the workplace, right? So if there's a close connection to that, then no matter the form or the forum through which the act is being committed, it will definitely fall within the purview of workplace related behavior, and so subject to the jurisdiction of the relevant authority, and in this case, the internal committee. So definitely, whoever tends to think that the posh law is going to be viewed narrowly, or the concept of workplace would be viewed narrowly, that's not going to happen. It's a beneficial legislation, definitely will be viewed in a sense which actually serves the purpose of the law. So that's what we need to keep in mind.
I think we all are in consensus with the thought process that harassment can go beyond physically meeting each other, beyond the four walls of the office. Rightly said. The second question is to you, Diksha. What are the key forms of harassment that occur in virtual work environments?
So again, it's ultimately just a different platform in which the interaction is happening, but the kinds or forms of sexual harassment would still be the same. Ultimately, when we look at the definition of sexual harassment, it covers aspects, such as unsolicited sexual messages, right? So that is something that can definitely happen on a virtual platform. Similarly, flirting in the course of a conversation, and that's something which is being deemed unwelcome by the woman. Again, an aspect that falls within the purview of sexual harassment. Other aspects like sexual jokes or innuendos, right? Or even sharing any explicit, images, or conducting yourself in the meeting while the camera is on in a way which is sexually suggestive. All these could be different forms of harassment that are occurring on the virtual platform.
Rightly said. I can also remember of this one scenario wherein there was a vulgar picture in the background, and one of the women's complained saying that there's a vulgar picture right in the background of that person, and it makes me really uncomfortable while we are even having conversation about work. So I think yes, it does impact people. Third is yes.
Just wanted to add one more sort of strange case that I dealt with once, which was virtual, entirely virtual, but a male employee had taken a colleague, a woman employee's social media, details, and they were friends on Facebook. This is back when Facebook was probably being, used by people. But basically, he pulled a few images of her from way before she was even in the company. And then he posted them, cross-posted them to a different WhatsApp platform where other colleagues were in the present day interacting for work purposes. So, you know, that it's strange, right, to do that, and then commenting on that, saying, oh, you know, she looks very boring in office, but actually she's fun outside. Look at this photo. So that sort of, even just trying to make a conversation around that, that was a posh complaint. We did look into it. So these things also, I think, may be somewhat indirect, may not look overtly sexual harassment-y, but you know, could make a person uncomfortable.
Definitely so.
One point I want to add there, ultimately we have to keep in mind that the conduct in question must have sexual undertones or overtones
Yeah,
it to fall within the purview of
yeah,
the POSH law, because we also tend to see a lot of cases where the main grievance that the woman has is that there is persistent calling over Teams at
yeah,
odd hours.
yeah,
There are constant messages coming in,
yeah.
and those messages need not be sexual. It's just that they're coming at odd hours or they are
Correct.
persistent in nature, and that itself becomes the focal point of the complaint. So
Yeah.
in such cases, the internal committee has to exercise discretion, and they do have the power to do that, where they examine whether the contents of those calls or messages were indeed sexual in nature, because merely calling somebody outside of working hours may not necessarily fall within the purview of this law. So that's something that we need to keep in mind as well.
I think even for when it comes to virtual harassment, there are new terms that we understand, such as doxing, threatening to leak somebody's private information online, impersonation, pretending to be somebody and discussing, talking to somebody else. I think these are various aspects of virtual harassment itself that now individuals need to recognize and realize that, okay, these are also few aspects, and then we have to work towards it. So thank you so much for that insight. Moving on, the next question is to you, Vasundhara. How can organizations adapt existing policies to address remote and hybrid workplace harassment?
So Sakshi, one thing I've noticed organizations do already is that the language of workplace is pretty much similar to the act. Usually that is what is reflected in policies, but I always suggest this to anybody I work with. You know, the policy is ultimately an employee-facing document. So can we simplify it instead of filling it with legal language? That is one thing to keep in mind. So when we are saying workplace, do we say it covers any and all arising out of? Instead of that language, can we simplify it a bit and say it includes online work, sort of online interactions or digital platforms, anything which an employee can quickly understand. So I think that is one thing I would suggest policies should include, that if it's unwelcome behavior, sexual nature occurring through digital communication platforms, that's it, blanket language. The second thing is to give examples. So there, if there is anything which of this nature, right, doxing or, cyber stalking or posting any objectionable content, virtual background which is inappropriate, anything of this sort that can be exemplified for the employee to understand that, oh, I have to keep this in mind, that can go a long way in preventing the incidents from happening. Because very often I feel that when these objections come, right, like the case laws we discussed, or even sometimes in posh cases, when Instagram is involved, for example, or if any app that is considered a personal app, like a dating app is considered, for the mind of the employee, especially respondent, it is not a workplace, so that clarity has to be provided through the policy. But yeah, that's what I feel. The other thing we should include is timing also. I think Diksha was touching on this, right? Like that, some industries may require this sort of a 24/7 responsiveness from the employees. It could be a logistics industry company, so it's working on a multi-time zone clock. But unless required for work, some language like that can help the employee understand that, oh, if it's not related to work, then I probably shouldn't be contacting my colleague, and vice versa. If a person is feeling that, I'm getting calls at odd hours, can they check over there and say, hey, this was work related. This was not then therefore sexual harassment. Can that clarity be brought in through the policy? That's something we should consider. Yeah.
I completely agree with you because I think employees have this question, well, while we have these training sessions and while we, have this conversation with them, I've seen employees ask, like, when you say unwanted video calls, what does that mean? Because our work is online based. We have calls and we have to get on video calls. So bracketing that unwanted video calls at odd hours, after work hours, wherein you're not in your whole senses. Some people get these drunk calls late at night. So that is something that we prohibit. We do not say do not call during the day when it's work related. So I
So,
think
and these unwanted video calls reminded me, Sakshi, a lot of my IC members ask me, Vasundhara, is it a crime if we ask our employees to switch on their cameras? Absolutely not. But again, if you are putting it in your documentation, in your policy, that goes a long way in clarifying, right? That something like all our calls are mandatorily video on. That is communication to your employees pre-call. In the call, then it's not a surprise to the employee that, oh, I have to switch on my video. Oh my God, I wasn't ready, or I'm in my bedroom, whatever it is. Then there's very little scope for that sort of a miscommunication to happen. So policies can go a long way in prevention, definitely, with these little additions.
yes.
Yeah.
Thank you so much. Diksha, do you have something to add there or like?
No, I think very helpful points, Vasundhara. Policy really makes things, more streamlined.
Yeah.
And I think I'm sure Vasundhara will also echo this thought that companies tend to just replicate what is there in the statute as it is, right? The entire policy document is just a replica of the statute, and they think that their job is done. They were supposed to adopt a policy, which they have.
Yeah.
But, instances like these make you understand that doing a superficial job is not going to do any good to the employer or the internal committee, right? So setting those protocols in advance, for example, the point about the camera being on during the proceedings, that leaving that discretion with the internal committee, or even the aspect of recording. I think that's
Yeah.
one part that
Yeah.
keeps coming up. That I could see that a recording was happening. No consent was taken prior. I was not informed about it, right? Or even the point of asking for recording. So leaving that discretion with the internal committee that the recording is being done solely for the purpose of their evaluation, and it's not meant for circulation amongst the parties. If that's what they plan to do as a matter of protocol, then it needs to be conveyed as well, right? Because then it tends to derail the inquiry process moving forward. So clarity is really what the policy framework can bring in.
Clarity and clear communication to the employees beforehand and not as a surprise to them in the call. I think organizations also need to be a bit mindful about that. Okay, moving on. Diksha, my next question is to you. What challenges do employees face in reporting virtual harassment and how can these be mitigated?
Very good question, first of all. See, one thing is that even when it comes to physical or in-person, form of sexual harassment, a lot of times these happen behind closed doors, right? So the lack of evidence part is something that you will see even in the case of physical sexual harassment, but it kind of becomes more pronounced in case of virtual sexual harassment, because at least in physical forms of sexual harassment, the conduct of the parties before or after the incident would be seen by other people at the workplace, right? Even if something is happening, let's say in a cabin, of course, nobody is there to actually corroborate either side. But once the woman, let's say, comes out of the cabin and she is looking extremely worried, distraught, right? And perhaps she sees a colleague, confides in them, or the other person themselves see that something is going wrong, so they come forward, ask those questions. So the circumstantial evidence is something that is still very much possible in the case of a physical sexual harassment. In a virtual setup where, let's say, both the parties are working from their respective homes, right? And it's really just the two of them seeing that happen in action. Nobody around is able to witness something even before or after. So then it becomes really difficult to, corroborate your position, because at the end of the day, you can't, as an IC, work with the assumption that the complaint would on by itself, be good enough evidence, right? You can't always work with that assumption. Ultimately, it's a balance of probabilities test. So the more direct or circumstantial evidence you are able to produce, the stronger your case will be. So in case of virtual forms of sexual harassment, that becomes quite a bit of challenge. The other is also about, the fact that apart from official channels like Microsoft Teams, sexual harassment can also happen, let's say, on Instagram, right? Where I see my colleague being there on Instagram. I try to flirt with them, send them a message, let's say at odd hours. I DM them. Now, in those cases, in terms of challenge from the respondent, right? One of the points that we often see is that I was, without admitting to anything, just saying that this is something that falls outside of the workplace domain because it was not connected with the work. I was not doing any work at that point in time. So the nexus test that I was talking about earlier, that is not getting met here. And these alleged messages were being sent outside of the working hours. So again, lack of connection with the work itself. The only workplace connection in that case is just the fact that the two parties are employees of the relevant organization. So this often becomes a point of challenge, preliminary objection from the side of the respondent when they're challenging the jurisdiction of the internal committee in such matters. So these are few, challenges that I can think of right now. Other than that, of course, a few things are common between physical and virtual forms of sexual harassment. For instance, fear of retaliation that often prevents the woman to come up and report about these instances. So those are common, but these were the ones I particularly have experienced in virtual cases.
Yeah. See, that reminds me of a case wherein this one colleague did send some vulgar messages on WhatsApp and late at night. And when this woman woke up in the morning and she saw those messages, she read those messages, but by the time she could actually take a screenshot, he immediately deleted all those messages and immediately sent a sorry. But she was, smart enough to capture that sorry, at least with the history of those deleted messages. But like it was very difficult for the IC members to establish that those were vulgar messages or there was certain kind of sexual harassment there. So as you said, it's difficult. We can not always work on that probability stance. But yes, the IC members paved their way there somehow. But yeah, rightly.
Good example that you've shared, Sakshi. When it comes to WhatsApp, Telegram, there is the concept of disappearing messages.
Disappearing messages.
In fact, in Telegram, there's an option where the messages can disappear in a matter of 10 seconds.
Yes.
So even before you can really screenshot it, the message is gone. At least in WhatsApp, you have, I think, 24 hours duration. So these are some real challenges that the internal committee has to face in these matters.
Similar issue with Telegram. I think earlier it had some secret chat option as well. So in one case, there was a girl who had, like, a woman employee had asked her friend to take a video of the secret chat as it was happening, because every time she was losing the messages. So she finally took the help of her friend and said, can you please record that this is happening? But I often see that that was a rare case where the complainant had the presence of mind to say, let me record evidence. More often than not, I think we get cases where the virtual harassment has happened maybe some time ago and now has turned into some sort of other, in-person harassment. So the evidence is lost, or, if it was Snapchat flirtations, at some point, maybe it was consensual. Once the consent has stopped, and yet the other party is not getting the message and they're trying to continue, to establish that earlier there was some flirtation on that online platform is difficult, because Snapchat inherently has a, I think, disappearing message feature. So definitely, I think the disappearing messages are a big problem when it comes to
I think that's a con for the virtual platform to us, and the IC members are trying to establish that yes, there's something wrong here. Okay.
Sorry, one last thing on this. I also feel that there was a case where the woman herself said that the deletion reminded me what Sakshi was sharing. she said she saw the messages and got so disgusted by them that she herself deleted them immediately. We could see in the messages that she had deleted messages. But she admitted that to the IC that it was repulsive to even look at that screen anymore. So I didn't know what else to do. I didn't want to keep going back there. So that also I think sometimes happens on
That's the
virtual
kind of
platforms.
impact those messages had on.
Yeah, exactly. But yeah, back to you.
So moving on to the next question, to you, Vasundhara. What role do digital tools and communication platforms play in preventing and detecting misconduct?
So I think in recent times there has been a heightened sort of effort from most of the of course the metas and the big social platforms, social media platforms of the world are actively doing this because of the sexual abuse faced online by children and adolescents. But then I think there's it's trickling up to the other ages also, and a lot of times because of that there are I think machine learning tools that those companies use, like digital platforms use it to scan any text that's coming through, either in the captions of social media posts or your image captions anywhere. They tend to mark any objectionable content. That said, I think that is an effort from their end, but there's always a option that they are providing to the user, which is to say, do I report this? Do I block this? And that is one way I think which sort of empowers the employees also. But if we keep aside social media and come to your more professional platforms like Microsoft Teams or a Slack, I think firstly they have some of them have enterprise models that empower the company then to say that can you moderate some of these conversations which are public. I think there's still Slack still has an option of private conversations, so those can't really be monitored, but at least whatever's in the public domain, if anybody has posted something objectionable, so that can immediately be flagged. I think even WhatsApp has such features, WhatsApp Business. So that's, I think, a distinction that they make between professional platforms and social media platforms. But beyond a certain point, I suspect the idea is to encrypt chats, because who wants everything they are writing to be read by some, a big social media company. So that I think is where probably they're also drawing the line. But these efforts are there, very much there.
Much, Vasundhara, for that. Tiksha, would you like to add something?
Yeah, anything.
Can we move to the next question?
I think we've covered it all. We can move to the next question.
Thank you. So, Diksha, how can managers and team leaders foster an inclusive and respectful online culture, workplace culture, actually?
Again, a good question, Sakshi. See, ultimately, it boils down to sensitization, right? And leading by example. Now, when I say sensitization, of course, it's not just about, yes, a policy on prevention of sexual harassment exists. You need to go beyond that and regularly communicate to employees certain clear facets, such as the fact that digital behavior is also a facet of code of conduct as much as physical conduct related aspects are, right? So making it clear that your behavior with colleagues, even on virtual platforms, can be monitored, can be actually taken into account when examining whether your conduct at the workplace is aligned with the ethos of the organization, or whether it entails disciplinary action. These messages which are being supposedly done, even in terms of basically, if we are talking about, let's say, a WhatsApp group that is created by a group of colleagues. Let's say if it's not an official WhatsApp group also, but letting them understand that even those groups and the interactions happening in those can be subjected to scrutiny, right? Is important, right? So that sensitization should be regular, and explaining to them things such as how do you use emojis, for example, being mindful of that as well, because sometimes I've seen in my interactions with colleagues also that sometimes somebody just harmlessly hard reacts to a message, right? They think that it's absolutely fine, it's being done in a friendly way, but not everybody can appreciate that, right? A thumbs up maybe would still be a reasonable reaction, but the moment you go beyond that, hard react to something, it could be a borderline case of sexual harassment. So being mindful of how you use the platform responsibly with decorum is something that you need to sensitize about, right? um, the key point really would be that, um, and other than that, explaining to them that calling somebody outside of work hours, right, or being persistent with your messages may not be sexual harassment, but would still form part of the code of conduct of the organization, right? It could still be regulated in that sense. Is still something that you need to teach your employees, right? So helping them with these examples, doing that regular sensitization is really the starting point. And like I was mentioning earlier, you lead by example. So the way you are conducting yourself in those messages, right, also would make a lot of difference. If you as a team leader are maintaining boundaries around the way you are communicating, um, others will follow suit, right? They always look up to their team leaders as well. So you need to keep in mind that your conduct can create a ripple effect. So that's really the starting point. And I think we can go a long way if we just make our communications and our teachings clear.
True. Like as you rightly said, managers, HRs, or leaders, we may say, they are usually the first point of contact for many complainants. And if they actually come up to them and say that, see, this is the kind of message that I've received, if the manager or the leader says that, okay, if they're just disregarding that complaint, saying that you have received this on your personal chat, how is organization going to do anything here? I think that is something that is not appreciated, and that should be changed. And sensitizing them is also very important, and understanding the use of right emojis. Nowadays, emojis have these different meanings. I think realizing and ensuring that we use the right kind of emojis, at least in a professional setup, is very important. So thank you so much for that, Diksha.
Actually, team leaders need to understand that this is not just an HR problem, right? Uh, Even though this might not be part of their KRAs, ultimately, if they are not keeping in mind that these explanations are important, it would create an inconducive, working environment, may result in attrition, cause workplace disruption, and ultimately have a bearing on the way they are working, right? So you might think that these aspects are not required to be addressed. Somebody's informally reaching out to you, and you are brushing it off, right? You are not telling them what's the next step, the next right step to report about an incident, right? So at that point in time, you may be dismissive about it, but later on, the kind of impact it can have on the organization will ultimately impact your work quality, your effectiveness as a leader. So understanding that your role is as important as the role of an HR is definitely important. You are not just another colleague; you are a team leader. So there are certain responsibilities that are attached to it, and one of which is to not be dismissive when somebody is, showing you those signs that that another colleague of theirs could could be resorting to inappropriate behavior. So being mindful of that is also important.
Thank you. Thank you so much, Diksha, for putting it out so well. My next question is to you, Vasundhara. What are the best practices for ensuring fair investigations and accountability in virtual harassment cases?
So I think let's start with something you just said, Sakshi. I think even for the IC, not just managers or leaders, even for the IC to acknowledge that something is sexual harassment on a virtual platform is sometimes difficult, because they too question, right? Is this workplace? Is this part of our job? Are we really supposed to look into this? So I would say that initial point itself is something that IC members should, as a best practice, inculcate. They should keep that in mind when a complaint comes. The first question is not to say this is your personal life. Rather to ask, how is this impacting your workplace relations in your team with the respondent? What exactly is happening? So even if it seems like a personal chat platform, whatever it is, to sort of get past that roadblock or mental, block, and say this will be accepted by us, and not to dismiss something, as Diksha said. Another best practice is for IC members to stay updated. So, we do all of our IC trainings, and we do add this as part of it. But it's easy for somebody who's senior leadership, who's busy. Usually IC members are senior leadership, and they're so caught up with other work that this may seem trivial. But to keep yourself updated about these, yes, some emojis these days are carrying a sexual connotation. Please learn about them, right? So that's also another practice that IC members can adopt. I would also say keeping up to date with some apps, and I learned this the hard way myself. I got a complaint about an app called Telonym, which I didn't even know existed. So apparently it's a anonymous feedback app that Gen Z is using, and again, it's something that is so novel. So is my duty to say I don't know anything about this, therefore I will not act on this complaint, or is my duty to say let me learn about this? So that kind of updation, I think, is important. From day one of an inquiry, I would say a best practice, especially in virtual harassment cases, is to strongly advise both parties to keep any evidence they have intact. I am tired of the number of times I've heard my phone just rebooted, my WhatsApp just got deleted, I just bought a new phone. So a lot of times, because it's tech, the possibility of something being lost is so easy. There are no physical witnesses to this conversation, for example. How are you want to capture it? So from day one, I think advising complainants and respondents to say that, look, whatever you have, keep it intact, screenshot it, save it, submit it to us so that we can keep it safe. That's going to go a long way in helping all parties involved, right? So I would say these little things go a long way, and sort of if there is a pattern that the IC is seeing in the kind of cases that are coming in, if there's a spike in the number of virtual harassment cases, can we include that then as part of our trainings? Can we sort of reiterate that message? And for managers, for employees, can we keep maybe clarifying that, look, even this is sexual harassment, even this is sexual harassment? That would go a long way. Or even this is workplace. That I think is the few best practices I can think of, Sakshi.
Thank you so much, Vasudha, for that. That reminds me of one more case wherein the complainant very, nicely she showed us the chats from one particular date to one particular date. But the respondent showed us few previous chats, which
Yeah.
very conveniently the
Yeah.
complainant had deleted.
Correct.
I think accountability there should also be on the parties to the complaint to show us the true facts and not play with the evidence, because it again comes to the IC with, we are left with a question mark, like, how do we go ahead?
Exactly.
I think accountability is also on the parties or individuals to ensure to keep those evidences intact and show everything to the IC and not conveniently delete things that they feel they don't want to show up.
Yeah.
Thank you so much for that.
Committees should understand that they just cannot simply say that, we just relied on the evidence that we had. You need to also go a bit further. For example, in the instance that you talked about, where a certain section of chats are being presented, WhatsApp chats, as an internal committee, you can't just say that, this is what we were provided with, and we placed our reliance on this. And because the respondent also did not have anything to say on that, we are proceeding with our observation, right? Why don't you ask for a proper chat backup, right? This is something that we keep asking internal committees, and they think that, this will be violative of an individual's privacy, right? So that privacy element often comes into the picture, which is why committees take a call that whatever the party has comfortably provided us with, something where they found comfort and they shared with us, we are going to just place our reliance on that and move forward. That means not be the right approach, because context always matters. So in order to gather complete context, you do need complete backup. So that's something that you need to keep in mind. Of course, your policies, your communications to parties need to have appropriate undertakings where at the outset itself, they are consenting to provide all relevant evidence, even collection of personal information in that process. So doing that as part of your policy framework will ensure that there are no unnecessary hassles later on when you actually ask for evidence or a complete chat backup.
Yeah,
At that
yeah.
point in time, if somebody says that, oh, because of privacy, I cannot share, you at least have that documentation with you to serve as a backup, right? That you yourself consented to collection of this. So that's one responsibility that internal committee has. That yes, it's kind of an adversarial manner of investigation where you rely on evidence, but then you also need to prod. You also need to ask questions.
Just want to build on this, something that Diksha said, right? Like the other responsibility I see has to thoroughly examine what has been presented. Because many a times, there's one case in which somebody else's number was stored as the respondent's number. You need to cross-verify everything. Now there is the new issue of AI-generated images, right? Like was this photo actually taken? So these are the questions we do need to ask. So even if evidence is presented, can we
Checking
sort of,
the authenticity of those evidences also.
yeah, veracity has to be confirmed. But yeah, that's it. I just thought of that. Yeah.
Thank you so much. My next question is to you, Diksha. How can organizations prevent misuse of digital reporting mechanisms while ensuring accessibility?
Yeah, I think on the procedural points, this is one of the most important challenges that organizations face. Especially in MNCs, you will see that there are so many portals established to report grievances, right? There would be a general grievance reporting mechanism. There would be an HR specific issue reporting mechanism. There would be an ethics hotline. Then there would be, a POSH specific portal as well. Employees often tend to get confused in terms of what really is the manner or the forum where they need to reach out, right? So we see that sometimes they would invoke the ethics hotline portal despite the company notifying the details of the internal committee and their contact details. They would still go via the ethics hotline route. The problem with that is that it compromises on confidentiality, right? If a complaint has sexual undertones or overtones, related allegations, then we know that Section 16 of POSH Act makes it mandatory that the contents of the complaint, the parties involved, these aspects need to be kept confidential. But the problem is that oftentimes these ethics, hotlines are regulated at the group level. So the parent entity would have set up an ethics hotline, would have notified even the employees of the Indian subsidiaries, right? That this is the portal where you can reach out if there's an ethics issue. And the moment somebody reports a sexual harassment complaint over there, it is made available to everybody who has access to the hotline. The company, the representatives of the parent company, the representatives of the Indian company, besides IC, right? So keeping in mind the confidentiality point here is important, right? Who are you giving access to? And making employees aware that different portals have different purposes. When your main grievance is in relation to sexual harassment, then internal committee is the right forum. Their contact details are XYZ. You have to reach out there and not these other XYZ mechanisms, right? So it's not a misuse, but it's just absence of proper use of the reporting mechanisms. So that's one thing that you need to keep in mind. Another related challenge is that when we talk about ethics reporting mechanisms, these allow for anonymous reporting as well. Now we need to keep in mind that the POSH regime does not allow for anonymous complaints. Courts have frowned upon anonymous complainants coming forward because it compromises with the principles of natural justice, right? If the respondent does not know who is the person reporting the grievance, how will there be an effective response to that complaint? And if you are familiar with POSH Act, it requires that mechanism that once the complaint comes in, the respondent has to present their own statement as well to the complaint. How will they adequately respond to it when they don't know who the person reporting is, right? So companies think that when they are coming up with these portals, and ensuring anonymity around these, more people will come forward. Sure, definitely that's the case. But then are we violating any Indian law as a result of that? Are we, perhaps violating the principles of natural justice in that process? We need to keep in mind that as well, right? So while you develop these globally recognized and globally aligned best practices in terms of digital reporting, keep in mind that you don't compromise on the local laws that provide for reporting in a certain manner. So I think these are a few points that I had in mind.
Thank you, Diksha, for that. You summarized it really well. I think that was really helpful. My next question is to you, Vasundhara. What steps can companies take to educate employees on virtual workplace etiquette and boundaries?
So I think we've touched on this a little bit in our conversation today already, Sakshi. So starting from the policy to the awareness sessions, highlighting, sort of examples for employees goes a long way in helping them understand that this is not okay in a virtual world, So many a times, I think the cases that I've seen of virtual harassment, there has been a sort of difference in the cultural or socio-economic backgrounds of the complainant and the respondent. So the way that they understand workplace relationships, or the way that they understand WhatsApp use, all of this leads to miscommunication. So helping an employee right at onboarding stage to understand that, look, it could even be that they're freshers. Sometimes transitioning out of college to work world is very difficult for a young person. So helping them make that transition, these are the ways in which the organization can do their part. Of course, we can't always foresee every possible situation, but again, if there is any existing set of cases that we are seeing coming up in the company, and we say that, hey, seems like our employee base is of this age or this bracket or this particular educational background, whatever it is, if there's any data of that sort that you're getting, using that to tailor then your training is always going to go a long way. And I think, of course, reminders around the time of a Valentine's Day, or just like a quick email or anything of that sort can go help employees to understand that I have to still keep it respectful, this is still a professional relationship. So those sorts of, I think, little bites always help. Reminders. Yeah.
I can actually remember of these organizations who actually come up and say that, can you, while you do that awareness sessions, can you actually reiterate that your boundaries are also beyond the work time. After your work shift ends, you still have to come, maintain that professionalism while you deal with your colleagues. So I think we have a long way to go there, but that really helps. Thank you so much. My next question is to you, Diksha. What lessons can be learned from case studies on managing harassment in digital workplaces?
Start with the point that Vasundhara rightly mentioned, which is proactive policy development, right? Understanding that, you know, putting things on paper just as they are set out in the statute that would serve the purpose. No, they don't. The case studies actually will make you understand that sometimes providing clarity on points upfront can help in ensuring that your inquiry process is more seamless, right? So as we were discussing earlier, the point about uh, asking, parties asking for recordings of internal committee proceedings, right? If your policy framework or your trainings can make it absolutely clear to the employees that even if there is recording happening, that will be solely for the purpose of internal committees' own evaluation of the matter and their internal deliberation only, then in the future, you can avoid those unnecessary questions coming in that, oh, why didn't you share a copy of those recordings? I want to hear, I want to develop my cross-examination questions based on that recording, right? So, case studies teach you that these questions can very well come up later on. So tackling them through a proactive policy development way or through sensitization through training can really go a long way. Again, case studies like the comptroller general case, right? That's also a case study in itself because it helps us understand that, beyond what the law itself says, if you look at the definition of workplace, what does it tell us? It talks about a place where, the employer has supervision or control, and it also covers places that an employee may visit in the course of their employment, right? But, virtual workspaces don't exactly fall in that zone, right? In the sense that you are not actually visiting another place in the course of your employment. You are actually sitting in your own home and working, right? So if you just literally look at the definition of workplace, as Sundara was also saying, it will not give you that guidance. But evaluation of these case laws, where courts are then stepping in and telling you that even these digital forms of sexual harassment are very much covered under the law, will again, help you understand what you need to do in terms of revisiting your policies, right? Making it clear that these forms of conduct can also fall within the purview of the internal committee. So learning about these case studies from time to time really, really makes a lot of difference, which is why I always say, I always tell organizations that, when you conduct these annual trainings to tick off that requirement that you have to sensitize, have people with legal background conduct these sessions, right? Preferably. Because these individuals will really, legal background or even someone who's sufficiently aware of the legal jurisprudence, right? Because these are the ones who will keep track of the evolving jurisprudence and will actually make you understand how the law is evolving. Just don't look at the POSH Act and the rules. Also see how courts are recognizing some of these cases, right? For example, the Ola case, right, where for the first time, you know, the Karnataka High Court, the single judge bench, said that, if there is a lapse on the part of the internal committee in inquiring into a matter, the aggrieved person can actually make a case of negligence against them. Who would have thought that an internal committee, in its own, independent right, can actually be subjected to a negligence-based action, right? Of course, that order got stayed, and we know what happened subsequently. But you can clearly see that internal committees are being held responsible now, more often than not. So, so case studies can help you understand the contours of these different concepts, workplace, sexual harassment, etc. Can help you in revisiting your policies or the manner in which you're conducting trainings, right? It can also help you, you know, uh, have better forms of sensitization. For example, the point that we was discussing earlier, how to properly use emojis, or how to properly communicate with your colleagues, even as part of personal WhatsApp groups, right? So case studies can help you with that kind of sensitization as well, right? Clear reporting mechanisms, case studies serve that purpose, right? That having the right kind of reporting mechanism, which ensures accessibility yet confidentiality, that matters, right? So case studies tell you that as well. And also the point of transparency, efficiency, right? Case studies will help you understand that in the course of the inquiry, parties often become very restless, especially the aggrieved woman, right? They will keep asking you the status of the inquiry proceedings, because even though the law allows you a 3-month time frame to complete the inquiry. It's difficult for the aggrieved woman to understand that. She would say that, oh, I've provided all the material to you. Why is it taking so much time? Right? So when you review case studies, you know that these kind of questions can come up. So ensuring that as an internal committee, you are keeping the parties informed of the status, managing those communications in a better way, that is also your responsibility. So case study actually helps you with that as well, right? So these are some of the, the points, the advantages or the learning points from case studies that I can think of. And I would definitely encourage everybody to, just subscribe to these platforms like Live Law, Bar and Bench, right? Even if you are not a lawyer, these platforms can help you understand what's going on with posh jurisprudence. Both websites are, keeping track of these judgments, and everybody needs to read those, right, to understand how quickly this jurisprudence is evolving and changing.
Just wanted to add a little bit onto this. You know, when Diksha mentioned complainants often get disgruntled also in particularly virtual harassment complaints, because these are also cyber crimes at the end of the day. And there are, some corresponding or separate provisions under IPC, under IT Act, which again, yes, preferably a legal practitioner could help with. But even then, even for the IC to, sort of say that, yes, you have the right to file under these things if you want to, that goes a long way in helping them feel heard. Because many a times the redressal they are getting through the IC may not seem enough to them. They may feel like, no, I also want to do something outside. I want to do this. And the typical, especially in virtual harassment, the typical thing I hear is, I want to file a cybercrime complaint. So, the IC's duty, of course, under POSH Act is to support through those processes also. So I think definitely staying abreast with the latest developments is very important. Yeah.
Thank you so much, both of you, for these amazing insights and inputs. So, just summarizing the whole conversation today, I think as individuals and employees, we need to understand to behave and have understand the boundaries and maintain respectful behavior outside workplace as well when we're trying to reach out to each other virtually. And when it comes to internal committee, assessing and recognizing the various aspects of virtual harassment while keeping up with the essence of the act is also very important. So yeah, that's how we conclude our conversation today. The platform is open for questions from participants. Does anybody have any questions? We are happy to answer. I think we have one question in the chat box. Which
Yeah.
laws cover virtual harassment for complete proceeding?
So Sakshi, I'm not sure I understand the question, and I would request Swapnil to sort of maybe help us a little bit with
Question.
yeah.
If I'm not wrong, I think he's asking for the laws which exclusively cover workplace virtual harassment. I think that's the question.
Diksha, would you be able to help with this?
Yeah, he said
Sure.
that's the.
Sure. So again, the starting point will definitely be the POSH Act framework. As we discussed, it's wide enough to cover instances of virtual harassment. Apart from that, as Vasundhara was talking about earlier, there are criminal laws. We have now a new law, BNS, which has replaced Indian Penal Code, that again covers sexual harassment as an offense.
Yeah.
So again, its ambit is wide enough to cover instances of virtual harassment. These could very well be cyber crimes. So we need to be mindful of that. It's not just the allegation or the offense of sexual harassment, but even associated aspects like cyber stalking, which themselves constitute offense under criminal laws. So primarily speaking, it would be a combination of these criminal laws, the POSH Act and the rules, and Information Technology Act as well, right? So these are the primary laws that will govern conduct happening virtually and through digital models.
Thank you, Swapnil, for that question, and thank you, Diksha, for answering that. Do we have any further questions? Anybody who has question to be asked? I cannot see any further questions on the chat box, though.
Yeah, me, Sundarajan.
Yes, sir.
I have a point of view. What happens is, actually, I found that the digital mode of harassment is very easy, but only it becomes difficult when there is a subtle difference between the two people where they had a transaction. So, very, very important is that if there is two-way transaction, and they have been having, and the girl also seemed to have had a fun in trying to show close relationship. When they found that when she wants to contradict or wants to show the abuse of the law, then she only makes a complaint with the sect of one that suits her. So very important is for the IC to examine, also to go into the veracity. Has there been any such transactions in the past history? Is it on the agreed women, and also from the respondent asking question is always better. Other process of sensitization on digital, which has mostly happened post COVID, which has enhanced. It is better to sensitize people through the posters, that what are the various digital mode of such one abuse will also attract. And more so, if there's a doubt, it is better for the IC member or the HR people to counsel such people. There might be double meaning either from either parties. That can be, one is abuse of the law, and second one is really very, very, both you have been using always being 50, 50, 50, 51, 49, like that. So that is sensitization to posters is very, very important. And also, though I don't agree with the recent judgments of the Allahabad High Court, where I found that Allahabad High Court judges were more male chauvinistic and more what do you call wrong side of the judgment, which has hurt the judiciary. All of us know that in the last 2 to 3 weeks. But the message is the women also not to give a leverage for the advocates or putting the high pressure on the IC members to protect them. So message is also through the posters or through the training, not to give scope for such things which have double meaning, either in the chat or in the one. So these things will help a culture of help the organization and IC to do their judicial process very correctly.
Thank you. Thank you so much, sir, for that. That really helps and adds on to the conversation that we had today. I think we also touched upon this somewhere during our whole conversation. So thank you. Thank you so much for that. I don't think there are any further questions. So I think we can, close this bridge. Thank you once again, both of you, for, being here, taking time out and being here. Thank you so much.
Thank you, Sakshi. Thank you, Diksha.
Thank you,
Thank you.
Vasundhara, Sakshi. It's been a pleasure.
Thank you.
Thank you, everyone.
Thank you. Bye.
Bye.